and two types of criminal contempt. One is interference with the functioning of the judiciary, direct interference. So somebody does not allow the court proceedings to function, disrupts court proceedings, he threatens a witness, threatens a judge. That's direct interference with judicial proceedings. That's criminal contempt, should be so. But the second part of criminal contempt is interfering with the administration of justice or scandalizing the court. Scandalizing the court or lowering the authority of the court. Now this is the problematic part, because this part of criminal contempt has been used to stifle even honest, legitimate exposure of wrongdoing or corruption in the judiciary, as a result of which the judiciary has acquired for itself or has acquired a second layer of protection even against exposure of wrongdoing within the judiciary. The third layer of protection was provided by a self-serving judgment in Veeraswamy's case, which said that nobody can even register an FIR against a judge for any kind of criminal offense without the prior written consent of the Chief Justice. A fourth layer of impunity has been added by self-serving judgments given regarding right to information with regard to the judiciary. The Central Information Commission has given a series of judgments asking the judiciary to reveal facts regarding the process of appointment of judges after the appointments have been made, facts regarding the disclosure of assets of judges, etc. But all those judgments have been stayed somewhere or the other, either by the High Court or thereafter by the Supreme Court, with the result that the Right to Information Act has become non-functional so far as the judiciary is concerned. So this is an important aspect of judicial independence, because unless you have proper and robust systems of judicial accountability, you will not be able to ensure independence of the judiciary from other extraneous influences. But coming to this aspect of independence of the judiciary from the executive, from the government, from the legislature, of course we have a perfectly satisfactory or reasonably satisfactory system by which the executive cannot, as in Sri Lanka, we have seen how the Chief Justice was removed by the executive. In India, that's virtually not possible, though ultimately it's really the legislature which votes upon the removal of a judge, but before that they have to appoint an inquiry committee, and that inquiry committee has to find that judge guilty, and therefore that's not practically easily possible for the legislature to sort of wantonly remove any judge. So that protection is there. The other way in which independence from the government is undermined is by the government having control of appointments. We know that earlier the government controlled appointments, as a result of which the government could appoint politically convenient people. It used to be said that in order to get appointed as a judge, you need to know the law minister, you don't need to know the law. But that was thereafter changed by the judiciary by a judgment which is known as the second judge's case, which all of you are familiar with, by which the judiciary took control of appointments. This certainly improved the independence of the judiciary in terms of the kind of people who were getting appointed. So that did enhance to some extent the independence of the judiciary from the government and from the executive. However, it did not deal with other problems in appointments, that is, arbitrary appointments, nepotistic appointments. They continued, non-transparent appointments, all these things continued. The only thing was that the government's influence in appointments was reduced, and therefore, to that extent, independence of the judiciary from the government was enhanced by the judiciary taking control of appointments. Now the government is using all the exposure that has recently taken place regarding nepotistic appointments in the judiciary, arbitrary appointments by the judiciary, etc. In order to, they have pushed through this Judicial Appointments Commission, in which again the government has got some role, though not a dominant role, but a significant role in the matter of appointments. And to my mind, without really improving the transparency or the non-arbitrariness in the system of appointments, without eliminating the problem of nepotism in appointments, etc., this new Judicial Appointments Commission will to some extent take us back, because it will increase government's influence in the appointment of judges. So this is one problem regarding independence of the judiciary, because if the government gets a significant say in selecting judges, that does compromise, because you can then appoint politically pliable, convenient judges and so on. The second problem of independence arises due to post-retirement jobs being offered by the government, which are under the control of the government. So far as appointments are concerned, we have been saying that we need a completely independent system of appointments, that is, a full-time constitutional body which has full-time members, not these ex officio members like the law minister, sitting judges, etc., because they don't have time. So you need a full-time body and selected in a particular manner which will ensure that in the selection of this full-time Judicial Appointments Commission, the government or the political class plays a small role, not a significant role, and that the selection of these people is largely controlled either by the judiciary itself or by other independent constitutional authorities such as the CAG, the Election Commission, the CVC, statutory or constitutional bodies, or the National Human Rights Commission, etc. So that's really the correct solution to the problem of appointment. So far as post-retirement jobs are concerned, see, post-retirement jobs become have a serious influence in compromising the independence of the judiciary, particularly when judges are on the verge of retirement. Especially if these post-retirement jobs are in the hands of the government itself. Governorships, these days even governorships are being offered to retired judges. So this is a post which is not only totally in the hands of the government, but completely at the beck and call of the government. It's of course a very cushy post in that sense. You are a governor, you live in great comfort, you enjoy yourself. So therefore, it's a serious way of compromising the independence of the judiciary. And that is why when this present government or the law minister says that, well, we are fully committed to the independence of the judiciary, you have to take that with huge bunches of salt, especially when you see the kind of things that they are doing. Same way they said that we are committed to a conflict of interest law, and the very next day they appointed as the cabinet secretary or as the principal secretary to the Prime Minister a gentleman who was a chairman of the Telecom Regulatory Authority. And they, by an ordinance, amended that provision in the TRI Act, which was intended to eliminate this kind of conflict of interest of getting of allowing this independent regulator to take up a job with the government. So therefore, you have to take, it is absolutely clear from the actions of this government that this government wants to have convenient judges, despite what they might be saying. So to avoid this problem of compromising the independence of the judiciary by these post-retirement job SOPs, my own view is that this independent Judicial Appointment Commission which I just spoke about, which should be completely independent of the government as well as of the judiciary, though the judiciary may play a significant role in selecting those people, this body should be in charge of all post-retirement jobs of judges as well. That means no post-retirement jobs given to judges. I'm not saying that judges should not have any post-retirement jobs whatsoever. Certainly not. They shouldn't be appointed governors. But they can do jobs with commissions of inquiry or with other tribunals, etc. But those appointments should not be controlled by the government at all. The government should have really no say in those appointments. Those appointments should be controlled by this Independent Judicial Appointments Commission. But there is another way in which the independence of the judiciary is being compromised. This is a somewhat controversial issue, which is arbitration. You see, arbitration has become a huge industry in this country, especially for retired judges. There are retired judges who are really earning tens of crores annually by way of arbitration, because of arbitration. It's become a very lucrative industry for retired judges. Most retired judges of the Supreme Court who are not having jobs in tribunals and commissions are doing arbitration. Now what this does is that it compromises the independence of the judiciary in two critical aspects. There is a group of corporate law firms which are engaged in commercial arbitration. The judges who are on the verge of retirement and who want to do arbitration after retirement know which these commercial law firms are. These commercial law firms are also appearing before them in courts. And therefore they know that if they want to get commercial arbitration after retirement, they would have to keep these commercial law firms happy. And therefore that compromises their independence so far as the cases of these commercial law firms which are involved in arbitration is concerned. But there is another more insidious impact of this arbitration industry, and which is this arbitration industry flourishes only as long as the judicial system, normal judicial system is dysfunctional. People resort to arbitration if and only if they know that in the normal judicial system their case will not get decided in a reasonable time. And this has created a very unfortunate incentive. I am using the words very consciously and deliberately. It has created a very perverse incentive in the minds of a lot of judges, especially those who are on the verge of retirement, to keep the judicial system dysfunctional. Among the PILs that I have filed for police reforms, administrative reforms, electoral reforms, etc., etc., some of the PILs that I have filed are also about judicial reforms. The first petition that I filed about judicial reforms about 15 years ago was dismissed casually by Justice Bharucha when he was in court number 2, I remember, merely on the ground that I had impleaded the Registrar General of the Supreme Court as one of the parties. And Justice Bharucha then went on to become the biggest arbitrator in this country, who probably earns the maximum amongst all retired judges by way of arbitration. Another petition that I filed subsequently for judicial reforms has been pending for the last more than 8 years with virtually no effective orders. This is despite the fact that in the All India Judges Association case, the Supreme Court 15 years ago or more than 10 years ago had passed a judicial judgment saying that the strength of the judiciary has to be increased 5-fold within the next 10 years in a phased manner. Now 10 years have elapsed. What to say of 5-fold? It has not even been doubled. It has virtually not even been increased 50% in the last 10 years. So therefore, if we have to avoid this kind of conflict of interest, I feel that some curbs will have to be put on this whole industry of arbitration, which has now come to engulf virtually every retired judge retiring, particularly those who are retiring from the Supreme Court. So these are a few thoughts that I had about independence of the judiciary. Thank you very much.
Thank you, Prashant. You have raised very stimulating questions and a broad spectrum of judicial reforms, which probably, certainly not during my lifetime, will be implemented. You also said that people say we are for the independence of the judiciary, we don't want conflict of interest, etc. I think the last word on such pronouncement and the best comment which I have heard was and read about is by President Charles de Gaulle. You might have heard of him. He was a famous president who fought during the World War. He was in exile. And then twice he became president of France later on. And he said, and I quote, "Politicians never believe what they say. So they are very distressed when others believe them." So please, not only bags of salt, not only a pinch of salt, but mountains of salt. So please go by this, what Charles de Gaulle said. They are distressed when you believe them, so please don't believe them. Huh? Now I ask our friend, the last speaker, Varun Jita from Mumbai, to share his thoughts with us.
Namaskar. I am not going to cite any this author, that author or whosoever. I am not going to cite any article. I am a common lawyer like you. I practice at a high court level or the courts which are subordinate to the high court. I am not practicing in the Supreme Court. I have some other different view. It is possible that some of the persons who are sitting here exclusively practicing in Delhi may not like that, but it is a ground reality. And I believe this is an occasion when those questions are required to be opened for a purpose of discussion before this August gathering. I'll ask 3-4 questions. Don't you think that this is also required to be discussed? This is also required to be deliberated so that let our judiciary become an independent judiciary. 1 or 2 small questions, and to begin up, I'll just say, if a client comes to me saying that, "Sir, I want to file a SLP in the Honorable Supreme Court," or while Supreme Court, somebody comes to me and say that, "Sir, I want to file a writ petition in the Honorable High Court," he will ask a simple question, "Sir, who should be a counsel?" The common litigant will ask, "Sir, you will take all preparations, you will make all preparation, you will make all whatever steps you will take, but who will be your counsel?" Now that common litigant knows that counsel is required because the judges are aware about the face law. Now don't you think that on this occasion we should also consider that let there be a rule of law which is governed by case law only and not face law. Let us go back. One more small example. The word uncle judges was heard by me in one of the conference which was organized by Bar Association of India.
Uncle and auntie.
Yeah, that's correct. And auntie also. What is happening today? Today the situation has changed. The second generation or the third generation of lawyers, instead of coming in the profession, they have started joining certain firms. Whether we are going to still say that no, still our judiciary is an independent judiciary. Why we are not thinking about that also? The corruption is not in terms of money. The corruption of mind is also the concept which is required to be discussed and deliberated now and now only. Otherwise, forget about this rule of law. I am apprehending that episode which our Upul shared about Sri Lanka, it is possible that somebody will follow you also. Somebody will follow me also. And we'll have to then find out in which court of law we can get a police protection. Let us come back, few more questions. Why there should be a rehabilitation program for the judges? I repeat, a rehabilitation program for the judges. Take a case that if a chief secretary retires from any government, he will be appointed as member of this committee, this commission, that commission, this tribunal. The same is applicable to the honorable judges. Don't you think that something is basically wrong? If you say that the judges are sacrificing their whatever personal life, then let them continue. Don't you think that the government will have to take some more burden about their perquisites, salaries, pensions? Otherwise, the rule of law is likely to frustrate. Let us consider one more example. There are few examples which I am going to quote. There are some judges who became judges of Honorable High Court, and then thereafter, before confirmation, they stepped down. They have tendered resignations. And ultimately, those judges have started appearing before their brother judges. Now, don't you think that this is also wrong? What the bar is going to do to uphold the rule of law in such situation? As and by way of a practice, all those judges who tender resignation gets a gown, gets a designation as a senior advocate as soon as the first possible opportunity.